In our last two segments, we spoke about co-parenting counseling and mediation as two possible ways that parties can attempt to peacefully resolve their differences without going through a contentious trial in court. And while each case is different, and the facts of each case may vary from one matter to another, in my experience, it's important to consider the fact that there is a general trajectory of contested cases that you'll see very often in cases, no matter where they're filed and no matter what the issues are. There's a start, a middle, and an end. And at least in my experience, the emotional peak of these cases tends to be at the beginning, when people have first either separated or filed for divorce, when the matter is new, when people are very upset, they're hurt, sometimes both sides are, and they have not yet gone through the process. So to some degree, people find themselves acting on automatic pilot emotionally. They're in the battle. Even if they have attorneys, they're speaking with their attorneys about how to win and filing papers and doing all kinds of things. And while no one's saying that that is inappropriate, the reality is if you're going to consider how to peacefully end a case, it may make sense to think about concepts like co-parenting counseling or mediation or a settlement conference or both as early on as possible. Because if you're first operating on automatic pilot and everybody's arguing and fighting and is ready for battle, you could be spending a lot of money and time and energies on something which may settle anyway, months, or unfortunately for some people, years down the line, when it could have settled much earlier had everyone handled it in a much more peaceful manner. So that doesn't mean every case is ready for co-parenting counseling or mediation on day one, but some are. Or you can be arguing your case while these things are going on. When I say argue the case, meaning preparing for the case. Sometimes you have to wait, usually, to get into court on a lot of cases. So the longer a case drags on, usually the more expensive it is, the more time-consuming it is, the more stressful it is. And then people end up sometimes settling a year or two down the line on the courthouse steps, and they say, well, we settled our case, but it's kind of sad because they might have been able to settle that case much earlier and save themselves a lot of money that could have gone to themselves or their child, and they could have saved themselves a lot of stress. It's also important to note that if you go to trial on a case, some people they think they want to go to trial. They're going to convince the court that they're right, the other side's wrong. Keep in mind that, and you speak about this with your attorney, that even if you were to win a trial, the other side might have an automatic right to appeal. So your case might not be over at the time of trial. So these are some incentives that people have to try to not only talk settlement, but try to, as early as possible, look at different ways to reach a peaceful settlement, a mutually peaceful settlement. In New Jersey, for example, where I sat on the bench, the settlement rate in most matrimonial cases was about 95%. Sometimes in some counties even higher. Now, that didn't come about because either side suddenly recognized one day that the other side was right, or they agreed with the other side. No. Cases tended to settle because it was in each party's self-interest to settle, because it was a way to save money, save time, save the risk of what a court might do, because you never know, no matter how strong you think your case may be, a judge may not agree with you or may see things a little differently. And you don't want to be stuck in an appeal situation, even if you were to win a trial. You want to try to save money and time. So talking about ways of settling a case, compromises, as early as possible is a discussion which should be had at the very least if you have counsel with your attorney about what are certain ways that you can try to move this case towards resolution besides simply waiting for a trial date, which may take a long time because the courts very often are backed up, especially after COVID when the courts were shut down during the lockdown. There may be a backup. Even if you're all set to go to trial, you may be waiting a long time to get to that trial. So you have to know these things, and you have to consider the possibility of at least considering mediation or considering co-parenting counseling, considering a settlement conference, just to see if the ball can get rolling sooner than later. And if you're waiting for the other side to start that ball rolling, you may be waiting a long time. So sometimes you have to discuss you initiating the process. When I mean you, if you're represented generally through your attorney, there's nothing wrong with starting that process. It's not a sign of weakness. In many states, there is a strong public policy supporting settlement of litigation, especially when children are involved, such as custody issues, parenting time issues. So you have to have this discussion if you have a counsel with your attorney. What can be done to initiate a process which will help end my case peacefully? The other side may not agree with everything you want. You may not agree with everything the other side wants, but the process of starting to discuss things, negotiating, compromising is important to try to do early on in the process. And if you're able to do that, you may be able to, sooner than later, reach a mutually agreeable and peaceful point C.